Nigeria loses sovereign immunity claim as U.S. court upholds $70 million award to Chinese firm. Gavel Court. Nigeria's claim to sovereign immunity cannot stand in a commercial venture, a U.S. appeal court has ruled. The court rejected Nigeria's sovereign immunity defense to the enforcement of a $70 million investment treaty award won by Zhongshan, Fucheng Industrial Investment Company Limited, a Chinese investor, in a free trade zone. Nigeria had, gruesomely, violated both fundamental and commercial rights of the Chinese firm, judges at the U.S. Court of Appeals in Washington, D.C. ruled. In a 2-1 verdict delivered on August 9, the majority ruling affirmed the judgment of the U.S. District Court for the District of Columbia that held that the arbitration award is enforceable. In January 2023, Beryl Howell, the presiding judge of the lower court, dismissed Nigeria's argument that the court did not have jurisdiction over the case since the country is a sovereign entity. Howell held that the court has jurisdiction since the United Kingdom, UK, where the $70 million arbitration award was issued against Nigeria, is a signatory to the New York Convention. Zhongshan Fucheng vs. Nigeria. In 2010, Zhongshan, through Zhuhai Zhongfu Industrial Group Company Limited, Zhuhai, its Chinese parent company, acquired rights to develop a free trade zone in Ogun State. A year later, Zhongshan set up Zhongfu International Investment, NIG, FZE Zhongfu, a Nigerian entity, to manage the project under the permission of the Ogun State government. However, things took a different turn in July 2016, when the investor accused the state government of abruptly moving to terminate its appointment while attempting to install a new manager for the free trade zone. Subsequently, Zhongfu initiated an investment treaty arbitration against Nigeria under the bilateral investment treaty between the People's Republic of China and Nigeria, the China-Nigeria BIT. The arbitrators had ruled that Nigeria was in breach of its obligations under the China-Nigeria BIT, and awarded Zhongshan compensation of around $70 million. In January 2022, the Chinese company initiated a case to seek enforcement of the arbitration award. Nigeria pleaded state immunity, but was turned away by Sir Kakaril, a High Court judge in the UK, who said the country abused the time frame for appealing arbitral awards. The U.S. Appeal Court judgment. In the majority judgment, the U.S. Appellate Court held that the final arbitration award is enforceable under the New York Convention since the dispute is between persons that share a legal commercial relationship. The court ruled that the Foreign Sovereign Immunities Act, FSIA, arbitration exception stripped Nigeria of the sovereign immunity in the arbitration award case. For the foregoing reasons, we hold that the final award is enforceable under the New York Convention because it arose out of differences between persons that share a legal, commercial relationship, the majority judgment reads. The District Court therefore has jurisdiction over this case under the FSIA's arbitration exception. The judgment of the District Court is affirmed. The majority judgment was issued by Patricia Millett and Juliana Childs. In the dissenting judgment, Gregory Katsars, the third judge, argued that when the New York Convention was drafted, the word persons did not include a sovereign nation. Katsars held that the action of Ogun State cannot be attributed to Nigeria, adding that the arbitration award arises solely out of Nigeria's sovereign acts governed by public international law. Text, legal context, and drafting history all indicate that the word persons, as used in the New York Convention, does not include signatory nations acting as sovereigns. I respectfully dissent, Katsars said. Nigeria losing case against Chinese firms in multiple jurisdictions. 3 days after the judgment of the U.S. Appeal Court, a Paris court in France ordered the seizure of 3 jets belonging to the Nigerian government over the dispute involving the arbitration award to the Chinese firms. In 2023, a court of appeal in the UK ruled that Nigeria is liable for a $70 million arbitration award in favor of the Chinese firm. The development means that Nigeria has lost arbitration award cases against the Chinese firm in France, the US, and the UK. The Nigerian government has accused the Chinese firm of attempting to use deceptive means to acquire the country's offshore assets.
With tensions simmering between Nigeria and its biggest bilateral creditor, China. Nigeria says it has uncovered secret attempts by a Chinese firm to take over Nigeria's assets abroad using unorthodox means. Now, the Chinese company in question is the Zhongshan Fucheng Industrial Investment Company Limited, and the dispute is between this firm and Nigeria's southwestern Ogun state. The asset seizure by the Chinese firm also includes presidential jets. Hearing the legal dispute between the Zhongshan and Nigeria's Ogun state, the judicial court in Paris ordered the seizure of 3 Nigerian aircraft that were en route to the routine maintenance in France. Now, these were newly acquired Airbus A330s valued at over $100 million. A Dassault Falcon 7X and a Boeing 737, previously a part of the Nigerian presidential fleet. Nigeria has accused Zhongshan of fraudulent activities and misleading courts in the UK, the US, and France to claim Nigerian assets. Nigeria has now commenced legal and diplomatic moves to reclaim its sovereign assets. It says the dispute is related to the Ogun state government, while the Chinese firm is targeting the Nigerian federal government and its assets that are covered by sovereign immunity and cannot be legally seized by foreign courts. Nigeria's federal government says it is not under any contractual obligation with the company. The dispute stems from a 2007 contract between Zhongshan and Nigeria's Ogun state to develop a free trade zone, but the contract was terminated in 2015. Nigeria claims by 2015 the Chinese company had done no more than erect a perimeter fence on the land that was earmarked for the free trade zone. But the Chinese company has been demanding restitution. It has already secured more than $60 million in an arbitration award. However, Nigeria has declined to pay up. Nigeria says the recent asset seizure is the latest in arm-twisting tactics by the Chinese company. The government says it is working with the Ogun state to resolve the dispute and to protect the country's assets from seizure. The international legal battle for Nigeria, along with asset seizures, comes at a time when its economy is already struggling. The West African country is facing its worst economic crisis in a generation. China, like I mentioned, is also the biggest bilateral creditor for Nigeria. So a standoff with the Chinese company could bring additional trouble for the Bolo Tinubu government. Now, for more on this, we have with us Dr. Chukwudiri Nwangwu, a political analyst and a postdoctoral research fellow at the University of Johannesburg's Center for Africa-China Studies. He is joining us live from Enugu in Nigeria. Thank you for being with us, Doctor.
Thank you so much. It's my pleasure to be here.
Right, let's jump right in. According to the Nigerian government, the Zhongshan Fucheng Industrial Company has targeted Nigerian government assets. What are the details about this dispute?
Okay, as you already noted in your introductory remarks, the whole issue could be traceable to 2001 when the Chinese and Nigerian government signed up to an international investment treaty. So the treaty was between the two countries, between the Nigerian government and the Chinese government, to the effect that they should be able to promote bilateral issues that border on investment, trade, and the like. So in 2010 or even earlier, the Ogun State government was able to reach a deal with a Chinese company known as Zhongshan. So it was able to reach a deal with the company to the effect that the company would develop a free trade zone in Ogun State. So what happened was that between 2010 and 2016, when the contract was revoked, the Chinese company had already been awarded a major shareholding right in the free trade zone by the Ogun State government. So, but suddenly, and under circumstances that have been unable to elicit a satisfactory explanation, the Ogun State government terminated the contract. As at the time the contract was terminated, it was reported in certain quarters that the Chinese company had invested a number of things in terms of infrastructure, including road construction, including power, energy development, as well as a sewage system, development of the sewage system. So those were the key things that the company had done prior to the termination of the contract. Although the Nigerian government would have us believe that it was only perimeter fence that was constructed prior to the contract termination. So following the termination of the contract, the company initiated a legal action against the Nigerian government as it were.
And what is the nature of the alleged campaign by the Chinese company? What contractual obligations, if any, did the Zhongshan have with the Nigerian federal government or the Ogun State?
Yeah, one is that Ogun State is one of the 36 subnational governments in Nigeria. And given that it has a subnational identity, it does not have express powers to engage in international diplomatic relations with foreign countries or foreign companies. So most cases, this is done under the auspices of the relevant ministries of the federal government, either the Ministry of Foreign Affairs, the Ministry of Trade and Investment, and so on and so forth. So, but Ogun State is a subnational government. And like I pointed out before, the contract is traceable to a 2001 bilateral investment treaty between the Chinese government and the Nigerian government. So in 2010, as it were, this treaty was effectuated through an investment of this Chinese company. So the investment essentially was about the development of a free trade zone in Ogun State. And the free trade zone, of course, is of international standard. So that contract was awarded to the Chinese company. So the involvement of the Nigerian government in the whole issue as it stands today is largely because the Ogun State as a subnational state within the Nigerian federal arrangement does not have express power to relate directly with the Chinese government or its companies. So that is why Nigerian government is being dragged in the International Court of Arbitration in France and so on and so forth. So it is the Nigerian government that is on trial and not necessarily the Ogun State government. So Ogun State government is a subset, a subunit or a sub-national government within Nigeria. So that explains why the Nigerian state is representing the Ogun State government, subnational government, in the ongoing dispute between the Chinese company and Nigeria.
And Doctor, China is the biggest bilateral creditor for Nigeria. How could this dispute impact relations between China and Nigeria?
Okay. There is no gainsaying the fact that China is the highest creditor nation to Nigeria and by extension several other African countries. And one thing is certain here, one of the immediate implications is that if it is not properly managed through the use of available diplomatic channels, it might soil the relationship between the two countries. Over the years, China had depended on Nigeria for raw materials, for minerals, not just Nigeria, virtually every other African country. So most of the loan facilities that Nigerian government has received from China is often tied to certain infrastructures. And of course, the Chinese government on the one hand depends heavily on Nigeria's mineral resources. So if this issue is not resolved through the relevant diplomatic channels, it might definitely affect both the trade and the diplomatic relations between Nigeria and China. Second, it might also affect foreign direct investment from China in particular, and even the Western world at large. Because Nigeria, as it stands now, is in dire need of foreign direct investment. So if Nigeria projects itself to the international community as a truce-breaking country, as a country that can hardly submit to contractual agreements, it will be difficult for potential foreign direct investors to consider Nigeria as its country of destination when it comes to investment. Then again, it might also make China and indeed the Western world at large to be more wary in reaching contractual agreements between them and Nigeria, even with respect to the loans, to the debt, because many African countries have not been very forthright in fulfilling their debt repayment obligation to the Chinese government. So one thing it might also cause is that it will make the Chinese government to be more careful when reaching certain loan agreements, both with Nigerian government and by extension other African countries. And again, one implication which might not be directly, one other implication which might not be directly related to China is that the whole issue has exposed the clandestine and opaque nature of the Nigerian government. Now, Nigeria, as it stands now, has been witnessing rounds of protest led by a group of youths who are largely aggrieved by bad governance in the country. And this thing cuts across issues that border on resource management and the wastage of public resources on the part of the government. So these two aircrafts that have been seized are has been newly purchased. And the just try to round off.
Dr. Nwangu, unfortunately we've run out of time. I'm sorry to interrupt you there. Thank you very much for being with us on First Post Africa. Thank you for your valued insights.
All right, thank you so much.
Thank you for watching. Don't forget to like, comment, and subscribe to Okasan the Journeyman TV. And ring the bell so you never miss any of our videos with the latest information, news, and adventures coming. We've got more exciting journeys coming up for you.